Good morning and welcome to another edition of Media in the Morning. I'm Meredith and I'm joined by my co-host Matt Diskin, and we have a very special guest here today all the way from Vancouver, David Wotherspoon, pointing himself out. He's a partner in the Vancouver office and also practices a lot in the media and entertainment litigation space. So following on the heels of our very popular Dead Celebrity Rights episode, the fan following was too much. We thought we'd sort of pick up on that goodwill and talk about zombie trademark rights. So, David, what are zombie trademark rights and why are we talking about them today?
Well, if there's zombie trademark rights, there probably are no rights. So, this came out of a discussion we had about the efforts by some enterprising entrepreneurial folks in Montreal to take advantage of a lapse in registration by Zellers over its trademarks, or at least a trademark, and they've set up a business using the name Zellers and restaurants and a variety of other things. Mm-hmm. So the question that has been asked in the media is, can they do that?
Understood. And so in considering that issue, what are the key kinds of factors that a court would have to look at if someone actually took this to a trial?
So I can give you a short answer, which I'll give you first, and then if you want, I'll give you the longer answer, which is...
Well, let's see how the short one goes.
Yeah, you don't want to hear from me in a long-winded way?
Well,
we only have 10 minutes, guys.
All right. So the short answer is that if a trademark has been abandoned, not just struck from the register, but abandoned, the owner has no intention to ever use it again, it is available for someone else to take up. And why they get called zombie trademarks is they're essentially dead, technical term, but also have some residual reputation, goodwill that someone might want to take advantage of.
Is that not going to be an impediment to the subsequent user, to that existence of goodwill? Does that not cause a problem in terms of the identification of source?
Well, the folks who'd like to grab up the zombie trademarks are doing it because of that very reason. They want to take advantage of the reputation and goodwill that's been developed in the past and use it as a launch pad for their new business.
But the Trademarks Office doesn't see a problem in principle with allowing someone to do that, to your best of your knowledge anyway.
So you have to distinguish then between what the Trademarks Office cares about and what the courts care about. So the Trademarks Office is, if it's struck from the register, a Section 45 expungement application, for example, they will allow it to be advertised, and maybe that somebody then opposes it. But what the courts are looking at is there an active registration? Assume no, but then the courts will also look at, does it continue to have reputation and goodwill? Or is it really abandoned? And
just for our viewers at home who aren't familiar with Section 45, that's a proceeding before the Trademark Office where you can get a trademark kicked off the register pretty easily and in a cost-effective way if the trademark hasn't been used in the preceding 3 years, versus we're talking about these court proceedings where there's lots of evidence, it's a lot more expensive, and us litigators have a ball in getting in the dirt there. So
yeah. So the longer answer. Sit back, relax, have a coffee.
Cheers.
So I didn't get a mug.
We're working on that.
Yeah. So in order to get a trademark in the first place, you can do it. You can have trademark rights in one of two ways. You can apply through the Trademarks Office, go through that application process, and get a registration ultimately if you're successful. Or you can have rights just by using the mark, called common law rights, which you enforce through a passing off action. But in order to have those rights, you have to prove you have reputation and goodwill in a particular geographic area. So if you have your trademark registered and you don't use it for a period of time, it may be that it's struck. That's the expungement process you talked about. There are other ways that you can lose your trademark rights. And that's what the Trademark Office cares about. Is it still active? And is there a reason to have it struck and make it dead? The courts have a broader view, and they look at, are there ongoing rights? Is there ongoing reputation and goodwill? And did an owner, in this case HBC, who owns the Zellers mark, did they have an intention to abandon it for all time, or did they have some residual interest to continue to use it. And so that's where you look. That's where the zombie concept comes from. I think I maybe just repeating myself, but it's dead from an administrative registrar perspective, but it still has some residual life in it.
So it's the living dead, if you will.
It's the living dead.
Now, what happens if you have an abandonment to Canada, but there's use in the United States of the mark, and we all know in the modern world, internet, everything bleeds over. Could that factor at all into this?
So whether or not an application continues to be live or to have some life in it, some zombie life, is a fact-driven question. The courts are going to look at a variety of factors. And even if it hasn't been used for a number of years, is there some indication that the owner of the historical reputation and goodwill has an intention to use it? So they may well look to, are they carrying on business in the US, and are they planning to come back to Canada at some point?
I see.
But there'll be cross-examinations and tests and challenging people whether they really intend to use it, or is that just a made-up story to try to keep it for no legitimate purpose.
So let's talk about sort of go forward and let's trademark hygiene and or revitalization, so that way these trademarks don't get invalidated. So what can our clients with trademark portfolios, maybe some marks that they haven't used in a few years, what can they be doing to prevent their marks from sort of being liable to this zombie territory?
I think that from a hygiene perspective is to keep an eye on your portfolio and ensure that you are using your marks at least once every 3 years. The use doesn't have to be extensive. I was in a dispute with over a trademark. A lawyer on the other side is now a federal court judge, but he very keenly organized a one-off barbecue for his client to create a one-time use in a 3-year period, which barred us from expunging the trademark. It was very clever on his part.
Great client.
The barbecue
also.
defense. I love it.
Barbecue defense. And now he's a federal court judge.
That's great. No, so I think it's making sure you're monitoring what your trademarks are, when they were registered, and taking pictures of that use at the barbecue.
Yeah. And I think that's something a lot of trademark owners don't do or could do better, is to actually chronicle or memorialize that use, so that if there's ever a challenge, you can say, here's the pictures of the barbecue and here's the picture of our product being used.
Excellent. Well, listen, we really appreciate your time and flying all the way to Toronto just for this very purpose.
I flew all the way here just for this.
It's great.
And I didn't even get a mug.
Well, listen, I told you, it's in the mail. But, my co-host Meredith, yes, I'm very grateful for your time, and thanks for tuning in for another episode of Media in the Morning. Stay tuned for some seasonal episode, or a seasonal episode at least, coming up soon. So take care. Enjoy your day.
Thanks so much.
Thank you. Bye-bye.
Dentons is a global legal practice providing client services worldwide through its member firms and affiliates. This episode is not designed to provide legal advice, and you should not take or refrain from taking action based on this content. Please see dentons.com for legal notices.